Okay, welcome everybody to today's webinar of dealing with the death of an SMSF member. You know, I did this, I put this webinar in there because I thought it'd be good to go back to a subject that hasn't really had any changes in recent times, and it's always a good refresher to do. But as is the industry that we operate in, we've actually seen a fairly minor change, but a change that took effect from the 1st of July, which I've incorporated into today's session around SMSFs and trusteeship when somebody passes away. So, you know, we've got some fresh material in amongst what is a relatively steady subject matter when talking about self-managed superannuation funds. So let's jump into it. It's got a fair bit of content to go through today and talk about the idea of what we do from a fund point of view when a member passes away. So they're really, for me, there's three areas that we're going to contemplate. We'll spend a reasonable bit of time at the start to talk about the trustee side of things when somebody passes away, and we'll also focus then heavily towards the end at the member level considerations and decisions that need to be made. And in the middle, there will be a little bit of talk about the things that we need to contemplate from a fund point of view, which is ultimately the fund tax position, because most things when it comes to the death of a member are really about the maintaining the trusteeship considerations and then obviously paying the benefits in accordance with the members' wishes. So they are our focus points of today's session. So from a trustee level consideration point of view, we're looking not just at the definition as it's contained within Section 17A of the SIS Act, but we're also looking clearly at the trust deed from a reference point of view, because the deed is ultimately the most significant document when it comes to certainly the trusteeship side of things, but also the payment of benefits. You know, it's less common these days to see restrictive deeds when it comes to the payment of death benefits, but I've certainly seen it. I've certainly seen deeds that exist that restrict payments of lump sums and pensions and other things. And so it's always important, if you've got clients with old deeds that haven't gone through any sort of process of upgrading over the last however many years, that it's worth to review what powers there are with regards to death benefits and trusteeship and payment of benefits as such. When we talk about fund level considerations, we're talking generally about ECPI considerations, you know, the continuation of exempt income when a member passes away, but also, you know, how we treat insurance proceeds and whether there are other deductions available to us. And then at the member level, we're talking obviously about their nominations. So binding nominations, the consideration of reversionary versus non-reversionary pensions, the flow on of that to the transfer balance cap, pension obligations. Also now, of course, Division 296. And whilst I've spent a bit of time talking to you about Div 296 over the past 6 months, I will, of course, touch on it today, but not with any significant depth other than an area that we need to be mindful of. So let's jump straight into our trustee level considerations and work through the areas that we need to be mindful of and comfortable with when it comes to the death of a member. So ultimately, you know, what you'll hear a lot spoken about when we're dealing with somebody passing away is whoever holds the purse strings controls the purse, and it's ultimately relatively true with obvious regard to things like binding death benefit nominations. But where you have funds where there is discretion, then clearly the person that is left holding the power holds all of that discretion. And the way that the legislation defines trusteeship, you know, it's not a mandated approach. You've clearly got this concept within Section 17A of the definition of self-managed super fund that provides for when something happens to the fund, that you've effectively got this 6-month grace period. And I'll touch on that a couple of times through the presentation, but you've got this 6-month grace period that says that, you know, if the fund doesn't meet the definition, then it still effectively meets that definition. So that clearly, when you then go through to the powers under 17A3, means a fund has the opportunity when a member passes away to appoint their legal personal representative of the member, so that person can be appointed. Any appointment is only going to apply during the period from death up until the death benefit commences to be paid. So, when does the death benefit commence to be paid? If we start an income stream, or alternatively, if we make an interim or a single death benefit lump sum payment. So, that period can be as short as 0. If it's a reversionary pension in place, then the death benefit commences to be paid immediately. So there's no LPR appointment going to occur in that event. If you've got discretion over pension, so it's non-reversionary pension, or if you've got accumulation interest, then until the point that first benefit is paid, either in a lump sum or the commencement of a pension, that's when the legal personal representative will be appointed. However, it is not a requirement of the fund, so it's a permissive requirement, or it's a permissive opportunity rather than an automatic opportunity, and that's where the trustee is going to have a fair bit to play in this place. And of course, we've got lots of cases, and so we generally go back and refer to the ones that had the most impact with regards to this concept of appointing legal personal representatives and the decisions that they get made. And so we look at the Apollo versus Conti, which there's multiple court cases in that regard, Worcester versus Morris, and clearly there's been a number, and we're seeing more and more of these every year. So, we've moved well and truly beyond the concept of the Katz and Grossman, which was our first real death benefit case that we ever really got to quote in the SMSF space. But that was a great lesson in itself, because the daughter of the deceased had been appointed whilst the member was alive, and then the daughter chose not to appoint her brother, who was joint legal personal representative, once Dad had died. And ultimately, the brother had no say, because the deed did not mandate the appointment of the legal personal representative. So it's an area that, despite being referenced quite regularly from an industry point of view, it's still an area that is questioned regularly. And clearly, when you see the cases that go through the courts, it's an area that is not always addressed, because one of the biggest challenges that person didn't appoint the executor of the estate, the legal personal representative, and therefore we didn't get the opportunity to be involved in the decision-making process. But the reality is, if the deed doesn't mandate it, so if there's no mandate requirement within the deed to appoint the legal personal representative upon the death of the member, then it is permissive, and the existing trustee can take whatever action they need. And that's what happened in Apollo versus Conti. So the wife passed away. The daughters were her legal personal representative, but the husband, and he was effectively, I guess, an ex-husband. They were still technically married, but they hadn't been divorced or whatever. But he resigned from being the individual trustee. So they were both individual trustees together, resigned, and he appointed a sole director company with himself as the trustee, and he paid the benefits out. And despite the initial court cases and the appeals, the girls who were the executor, because the mum had actually made historical binding death benefit nominations, but they were no longer valid. And then in her will had made reference to leaving her superannuation proceeds to her daughters. But because A, the nominations weren't binding, and B, the LPR appointment was not binding on the fund either, the sole director company that the individual had set up was sufficient enough for him to pay the benefits out as he so chose. So, it's an area that people need to continue to monitor, particularly as circumstances change in fund events and in family events as well. So, key consideration is that legal personal representative appointment, and how and when, more to the point, what the deed says with regards to any appointment. Because ultimately, if there's no binding death benefit nomination in place, then all control is going to resolve or sit with that surviving trustee, and they can then pay the benefit out. Sure, they've got to go through the various processes to make sure that it looks like that they have identified who the appropriate beneficiaries might be. But once a decision's made, they don't give reasons for those decisions, then there's very little action that can be taken in regards to taking action against the trustees in a court point of view. So it is an area of I guess, interest in the death of a member piece, is that we always need to be planning for what the fund has to do from a trusteeship point of view when somebody passes away. So that's always going to be the first piece there. So I have a question here. If a binding death benefit nomination is in place, then trustees should not be following this document to pay off the death benefit. No. So if there is a binding death benefit nomination in place, absolutely the trustee should be following that. And we'll talk about binding death benefit nominations as we go through. But yeah, you can't just, as the surviving trustee, you can't just pay benefits as you choose. But if discretion is provided on the payment of benefits, and let's be very clear that lots of super funds out there would have that discretion because people don't always have binding death benefit nominations. Then if there is discretion, then the trustee can pay the benefit to a CIS dependent as they see fit. So it's one of those areas that certainly can exist. So let's move on. So with the appointment, as I said, it's permissive, not mandatory. We've got this concept of the timing of the appointment, and the key things around that timing of the appointment are all ultimately linked to the initial timing. So the date of death is where we can have an appointment to be made up until the date the death benefit can be or can commence to be paid, whether it be a lump sum or a pension commencement. You've also then got the 6-month rule under the definition of 17A as to when a fund fails the definition of a self-managed super fund. So there's ultimately almost a two-tiered factor when it comes to estate planning there, because you might have a situation where a fund becomes inactive. And I think one of the things that's always clear when there's a death benefit, and this is a conversation piece that I've been having a lot, particularly the introduction of Division 296, is that often we see death benefits in an SMSF environment take time to be paid out, right? And that can be through a number of reasons, either decision-making powers. So, there's a fair bit of thought going into the process as to what to do. And so that extends the time frame to pay the benefit out. Disputes, obviously a dispute will expand and extend the period of time that it might take to pay a death benefit out. But also, if the estate needs to determine probate, if there's a question mark over who the legal person or representative is, to be able to make that appointment. So if the deed mandates an appointment, but there's uncertainty around who that LPR is, well, then it's going to have to go through the court process to get that LPR determined to be able to then make the appointment as well. So there's all these different triggers that can impact the timing piece around that 6 month and the definition of a self-managed super fund. And then equally, once the death benefit is paid, so if the LPR is appointed and a death benefit is paid, then does the fund need to appoint a new trustee? Do they have individual trustees and they need to appoint a second trustee? Or do they have a corporate trustee and therefore a sole member, sole director company will suffice? So there's lots of things to take into consideration. And clearly one of the best outcome is, if there's not going to be any appointment considerations, then to get the whole death benefit paid within 6 months, clearly ideal, because then the fund can be restructured and satisfy the definition of the SMSF trust of an SMSF moving forward. Now, I said there's been a change, and this change, if you're keeping up with all of the legislative stuff that's going on at the moment, I mean, between Div 296, between LRBA changes, there was also a whole heap of other tax changes and legislative changes that came through and received royal assent on the 30th of June. And one of them was effectively a technical correction or, an admission to the previous legislation that addressed the idea of if somebody's appointed the public trustee, right? And so if someone has appointed public trustee either through the death, right, or through, say, disability where they've lost legal capacity, then effectively it was identified or determined that that created a bit of a hole with regards to the appointment of the legal personal representative under 17A. And so new powers have been introduced to say that the public trustee can appoint somebody as an individual trustee or as a director of a corporate trustee to act in the place of the member when they've passed away, and similarly under legal disability as well. Now, it takes effect from the 1st of July, so it is in effect now if we've got public trustee type appointed funds or members that have a link to the public trustee. The other thing is, of course, that's a critical thing because 17B says you can't be remunerated to be trustee of the fund. Well, there's now a new exclusion in 17B that provides for the ability to be remunerated as trustee for undertaking your performance as trustee if you're qualified to do that role and you've been appointed by the public trustee. So that's, as I said, we've had some change. It's only a minor change. It's not going to impact a lot of self-managed superannuation funds, but it just does give that clarity for self-managed super funds where the members have a link to the public trustee, for that public trustee to be able to appoint a natural person to act as director or to act as individual trustee of that fund under the same conditions such as the until the death benefit is paid and all those sorts of things, but the difference being that person can be remunerated. So a change that we've seen come in ultimately over the last couple of weeks in that regard. So of course, what we know is that our fund requirements are that if we've got a single member fund, then we must have at least 2 individual trustees, right? So we can't just have the single member on their own. If we've got 2 or more, then each person needs to be a trustee as well. From a corporate trustee point of view, you've got that one difference, right, where you can have a single director, single member fund. So that the main issue for self-managed super funds that we have is when you have a sole member and they pass away, because if they pass away, then you've got to go through the process from an appointment point of view of whatever is required under the Constitution to appoint a new director. So identifying that the legal personal representative, it's most likely going to require subject to a shareholder meeting. Now the LPR might receive the shares as part of the will. So again, it can take a little bit of time if you've got a single member sole director company trustee arrangement in place. But they're the things that we need to consider when it comes to the appointment of a trustee for a self-managed superannuation fund. As I said, most funds don't have the power written into the deed to mandate that LPR appointment, right? And so I make that comment based on the deeds that I've worked with over a long period of time, and so it's one to always seek clarity on. But in most instances, people are using that permissive power to appoint the legal personal representative, and so it is certainly a key area that people need to be mindful of. Now I've got a question here. How do the disqualification of a trustee for not being a fit and proper person work where in a DFV situation, so domestic violence situation, one trustee has murdered the other? This is in light of recent government consultation on preventing perpetrators from accessing super benefits of the victim. Yeah, so I think we know that there's been a fair bit of work in this space where people are the victims of domestic violence, and certainly ensuring that the super proceeds can't go to that the perpetrator in those events is where the legislation's been headed there. Now, there's a secondary piece to that, which is where the question alludes to there, which is around the disqualification. Now, disqualification is quite specific when it comes to superannuation trusteeship, and that is that the disqualification either has to be on the grounds of, say, insolvency, has to be on the grounds of being committing a crime of effectively a fraudulent nature, so dishonest conduct in that regard, for breaches of the SIS Act, or under this guise of a fit and proper person. So it's ultimately comes down to the fact that it's not an automatic disqualification. So if somebody has been committed of a crime that is not financial in its nature, then we see an issue there around that fit and proper person piece. Now, what we have seen with the legislation and the proposed changes around that piece is that we have seen the suggestion that, and this is all linked and also to the victims of child sex crimes and that as well. So there's a whole lot to still play out in this place, but automatic disqualification when you are found guilty of those places. So that will have an impact, but we still have a little bit more to play out in that place. So lots of key things to contemplate there in regards to it. To appoint a new director or trustee, does this new person need to go through the AML or CTF check that started in July 2026? Look, the key thing there is if you're setting up a fund, and if you're creating a new fund, you've got to set up and potentially, so if you're setting up companies and if you're setting up trusts, that's when the AML CTF stuff comes into it for the super fund. So knowing your client in that regard. From an appointment point of view, it's your ability to clearly undertake and become a direct or get a director's ID. So whatever the requirements might be there, and to not be a disqualified person. So, there's two different things to consider there. And the AML CTF are not around trustee appointment. It's more about fund establishment and corporate trustee establishment, not about appointing new people. Those people are subject to the existing rules under the consent to act as trusteeship. So a number of things to certainly contemplate there. Another question, an SMSF has one adult member and two minors. They have corporate trustee structure where the adult's the only director. Yep. If he or she dies and the BDBN is in place in favour of the minors, then who would be LPR or trustee of that self-managed super fund? Well, it's a little bit of a how long is a piece of string question, because clearly if the two children are still minors, then ultimately we need to find somebody that can come in. So you would assume that the parent has has an executor of their will, right? So has already appointed, you would hope, let's just go back and say you would hope that they have created a will, and in that will that they have named an executor, and that executor understands that as executor of the will, that they would be their legal personal representative, and so therefore upon the death of the individual can accept the position of trustee of the self-managed superannuation fund. So, this is one of the things that I always talk about in this space, particularly when sort of contemplating estate planning and self-managed superannuation funds, and that is that when people are completing enduring powers of attorney, when people are completing wills, and I think it's mandatory if you've got a self-managed super fund that you should have both of those documents, that the person you want to be your effectively your executor, the legal personal representative, they need to understand that you have a self-managed superannuation fund, and part of them accepting that role may require them to be appointed as the trustee of the fund in the event of loss of capacity or death. And so that scenario, I think, would definitely play out where you've got minor children and a sole surviving parent or whatever it might be to come in and act in that place. Excuse me. Now, where you might have an issue, and I've certainly seen this issue arise previously, is where you've got, and by the way, this is not a legal presentation, obviously, and I would always be suggesting to anybody to go out and seek the appropriate legal advice when dealing in this space. But where you've got potential issues that will arise there is if you've got a single parent in that regard with minor children, and they're not single because of death of the other party, they're single because of divorce or something else like that, then, does that other parent, as the parent or guardian of the children, do they have capacity to replace the deceased parent when they die to run the fund? Now, SIS would say yes. Will the courts say other thing? And I think that's where it's going to get potentially really messy, and people need to have certainty and clarity around that, because under a pure reading of 17A, the parent, the surviving parent, who may not have custody of those children through separation or divorce proceedings, would meet the definition of their parent under the SIS Act, and therefore could act as trustee in their place. And so, as I said, you need to get absolutely get legal advice in regards to that before taking any action. So look, some really good questions to come out of that trustee piece, and clearly, with a lot of the stuff, and I think there's a great question around the domestic violence side of thing, which is an area that is continuing to evolve, and I think not quick enough in the SMSF space from an activity point of view, because we need to have certainty in regards to those areas. So then when we move on to the fund level considerations, some of the things that we need to talk about there is clearly we've got assets in the fund. What's going to happen? Are we disposing of those assets? Will those assets be transferred in specie? And I was talking to a colleague only yesterday, actually, in regards to a self-managed superannuation fund, and they have gone through the process where the member passed away, and in those circumstances, a lot of the assets will be sold down and paid out to the spouse, and then other assets will be transferred as in specie payments to the adult child, so non-tax dependent. There will be PAYG, and that was one of the conversations that I had with them to understand that yes, you can do in specie transfer of assets when you have a death benefit, but remember and recognize that where you have non-tax dependents, as we'll talk about soon as well, there is a tax element to consider. So many different things to factor in when we're talking about the death of the member, and this is the issues that will obviously potentially drag out the payment of death benefits, is dealing with the assets of the fund. And also, do we have liquid assets? Are they illiquid? Do we have properties in there? What are we going to do with regards to that? Understanding how ECPI works, and understanding that, if not all pensions are reversionary, that there is, a capacity for ECPI to continue on beyond the death of a member. And this stems back, the pension ruling that we saw come out 2013-5, which has been amended recently around when a pension ceases or not. That sort of created a lot of friction back in, say, 2012, 2013 time, when the ATO identified that your ECPI or pension ceases upon the death of the member, and effectively that would then have a flow-on effect of losing ECPI. And what we saw eventuate from there, and has now evolved to the position where we're finally at, and that is that the exempt current pension income is maintained up until the point that death benefit is paid. And that's a critical thing to understand, because it gives certainty around the tax position, or a bit more certainty around the tax position of the fund in most sets of circumstances. Of course, Division 296 throws up a different spanner in that regard, but if we factor the reality that the majority of superannuation members where there is a death benefit to be paid, if we make an assumption that the majority of those are pension age members under $3 million, right? I think that's a reasonable assumption to make based on the numbers that we know from the tax office. Then in most instances, you'll have an ECPI period with that pension that's going to cover off on the tax liability of the fund, to sell down those assets to pay the benefits out. So there is that comfort there, but you have to understand the difference in that regard between reversionary and non-reversionary pensions. And what you also have to understand is how insurance can impact a death benefit, with reference not only to things like the untaxed element, and we're not drilling that deep down today with regards to untaxed elements and things like that, but noting that insurance proceeds hit differently based on the interest they're going to. Are they going to a reversionary pension? Are they going to a non-reversionary pension? Are they going to an accumulation interest? And how insurance proceeds are impacted by ECPI as well. So whole heap of things to consider in with regards to the fund piece, which is often linked to where we have the benefit paid. So another question: do we have any further clarification on the ECPI on death requiring it to be paid as soon as practicable? Look, the short answer to that is that the ATO actually recently, and I've got to go back and review it. I've looked at. I did have a bit of a read through the links of the pages that I've got within the webinar today, but they actually removed the whole the time frame around as soon as practicable, right? And so that they've, because there was always this expectation or understanding that as soon as practicable meant 6 months, right? Now, that really stems from, if you want to dig deep into history, things like as soon as practicable and 6 months all stem from quite specific legislative requirements to do with taxation, and prior to 2017, a lot of it to do with the timing of benefit payments. And so if you had an income stream and then you took a lump sum from that income stream, if that lump sum was taken outside of 6 months, right, then that would be considered a member benefit versus a death benefit. Now, that all disappeared in 2017, and they said once a death benefit, always a death benefit. But these rules go back further to that. They said that the changes in legislation occurred around 2013, 2014 to expand that ECPI period. So the concept of as soon as practicable is still very, very much driven more from an industry approach than anything definitive from the regulator or the legislator. And that is that if you're operating inside a 6 month window, you've got really no issue with what as soon as practicable means. But beyond that, as soon as practicable means ultimately what process is the fund going through, and it might be as I said before, the appointment of the LPR. So there might be the executive thing, there might be the selling down of the investment, and that's going to be the key thing. If you've got illiquid assets, if you've got property investments held within the fund and maybe held within a unit trust or something else, then those assets will often take time to liquidate, right? Now, the key to as soon as practicable there is concerned is that, are you waiting for the time when you know the price is going to be right? Well, then that's not as soon as practicable, right? And only the facts will identify those sorts of key issues. So it's really about what steps are the trustees taking once the trustees are appointed to redeem investments to be able to pay the benefit out. And so as soon as practicable can ultimately extend well beyond 6 months in certain sets of circumstances. And so it could, as you then state, it could possibly take years. And I have seen death benefits take years. Clearly we don't want that. Clearly we want payments to occur quicker. But that's certainly something that we need to be mindful of. And of course, now when we're factoring in all these decisions around fund assets and other elements as well, we are having to consider what that all means in relation to Division 296 as well, and what that means from a fund's position. So there's a lot to factor in, and one of the comments that I'll make there, and that I've put on the slide there, is that the ECPI, so the exemption, applies to the death benefit, so the interest with that's linked to the death benefit and any earnings, but it excludes earnings attributable to insurance proceeds. Now, that in itself was quite a specific change that was made to say that, okay, well, we've got a member passed away and they have X amount of money sitting in their fund, right? Now, if the pension is reversionary, well, that continues on as a pension interest, right? So we forget reversionary pensions when we're talking about ECPI, because the deceased money is gone. It now belongs to somebody else. So that's a very clear-cut case. But if we have somebody with a death benefit, with an income stream, so they're paying an account-based pension, it's not reversionary, right? So this is where this ECPI piece takes effect, is that they die and the trustees have to make a decision with what to do to pay the benefit, what to do with regards to paying the benefit. So the fund could potentially take a number of months, right, to sell down those assets. The ECPI will flow through on the sale of those assets. But then at some point in time in that decision, if that interest held insurance proceeds and the insurance hits the fund, then the ECPI does not apply to the insurance proceeds, right? And more importantly, because insurance is not a taxable event, more importantly, the earnings on those insurance proceeds are not subject to the ECPI. So clearly, the key is in insurance-driven scenarios, if you can sell down all the assets and pay out all the assets before that insurance hits, then you're going to get that full ECPI bit, and then clearly know that any earnings that you generate from the point the insurance money comes in will be potentially taxable. But you want to ultimately find that insurance or have that insurance event as the last event before you pay the benefit out, or commence a new death benefit income stream. And one of the key things to that is that there was a change in the income tax regulations to say that from a proportioning point of view, what we know is that when you are in pension phase, your tax-free and taxable components retain their proportion from commencement. So that, if you start 50-50, then everything up to and including the death benefit is going to be 50-50 from a tax-free taxable point of view. That means all earnings are treated the same way, right? So we know that it's ECPI anyhow, and we know that it's non-assessable income from a member point of view. This regulatory change that came in basically said that insurance proceeds, when they hit the fund in a reversionary pension, they hit it on the same tax-free taxable componentry. In a non-reversionary pension, so if the deceased person, as it points out there, was receiving a pension immediately prior to death and no reversionary beneficiary existed, then the amount that hits the fund will all be taxable component. And therefore the earnings will also be taxable component. So it's almost that you create a secondary interest on top of the existing death benefit interest that existed for the member at that point in time. So some little clarifying elements. And of course, how many death benefits incorporate insurance, that's always going to be, fairly subjective with regards to self-managed super funds, because a lot of older members no longer have insurance in the fund, and just have to consider it as part of their strategy. So when we look then at the member level considerations, and this is where we'll sort of hit some of the conversations around binding nominations, but also the taxation of things and transfer balance cap and reversionary versus non-reversionary pension. But the member level considerations is clearly, well, to me, if you get the member stuff right, then it clearly helps with, say, some of those questions we had before around BDBNs and trustees making bad decisions or whatever. Because if the members have the power through the deed to create nominations that satisfy their requirements, then often that trusteeship stuff really is of far less impact, other than meeting the definition of a self-managed super fund. Pretty critical, I appreciate that. But if the nomination side of things is done correctly or appropriately, then you can avoid a lot of those sorts of things. So what we need to understand from a member point is the compulsory cashing nature of a death benefit. And that is, as I mentioned earlier, a death benefit is always a death benefit. So once somebody passes away, if their benefit is reverted to a spouse, or to a child in certain circumstances, if they're as a pension, if they're under 25, I'll touch on that a bit later as well. In those circumstances, those monies don't get merged with any accumulation monies. They sit as a separate death benefit interest for the recipient. And so therefore the treatment of any money from that, any withdrawals from that, will be treated as a death benefit. And so it's always an interesting one where we talk about paying a death benefit out. Member passes away, you can pay an interim and a final death benefit. So ultimately two payments to pay out that amount. If you commence a pension, right, with the full proceeds, then you have paid out 100% of the benefit, right? It is now a death benefit income stream. So any payments, any commutations that you make from that are not counted towards that 1-2 interim or whatever. They're just purely death benefit commutations from that initial income stream. So, we don't have the capacity, which we did have before 2017, to roll back the interest to accumulation. Now, when I say we did have that capacity, legislatively, it was always a bit confusing, and the regulator came out after 2017 and said, actually, you never had that power. That's not what the legislation said, but we understand that's how the industry interpreted it. And so any action before 2017 won't be looked at, but everything since 2017 is very clear Once a death benefit, always a death benefit, and you must pay that benefit out. So we have to understand the compulsory nature of it, and that's also where as soon as practicable becomes a key issue. It also means we have to understand the definition of dependency, so cis dependency versus tax dependency, because cis dependency determines who we can pay benefits to. Tax dependency determines whether any tax liability is attached to the payment. The instruction side of things. So does a member make a binding nomination, a non-binding? Is it lapsing? Is it non-lapsing? What does the deed say? Do we have a reversionary pension or a non-reversionary pension? And again, each to their own with one versus the other, reversionary versus non-reversionary. I'll run through a couple of the key things on that in a moment. What does it mean from a transfer balance cap point of view? So from a transfer balance cap point of view, it means absolutely nothing for the deceased, right? Because your transfer balance cap dies with you. But for a spouse, it means a lot. For children, it means a modified transfer balance account. And it's clearly having an understanding of the ramifications of death benefits in those scenarios. Div 296, as I said, I've spoken a lot about this in recent times, and the key issue with Div 296 is that statistically, very few people are impacted by Division 296 outright in year one, right? A small percentage of individuals. However, when we then look at death benefits and when we look at adding the combined sum of two members together, that will impact people and that will put people into a Div 296 environment. And so the estate planning question is really now a big part of the Div 296 planning. If we've got two individuals who are operating under the general transfer balance cap, which is $2.1 million, combined, we've got 4.2, right? So anyone with any fund with basically any fund with more than $3 million potentially is going to be impacted by Div 296, subject to what happens on the death of one member and then the actions of the second member. So all these sorts of things become pretty critical. Taxation, there's a question there, but I'll get into taxation in a moment, so I'll answer that question as part of the presentation. So from a compulsory point of view, it must be cashed, and it must be cashed as soon as practical. As I said, there is no definition. So reiterating that point from before, there's no definition of what as soon as practical is. It just basically means that we've got a position and we have to, once we can make a decision, from whether it be from an appointment point of view, an asset sell down point of view, then we need to act. We can't wait. And I had a client question, probably only 12, 18 months ago, maybe, in a situation where the individual had died and they held an investment, and the advisor, I think it was, came back and said, oh, look, that investment is going to mature in 12 months time. In the sense, when I say mature, it was the valuation was going to mature and it was going to be worth 5 times the amount. And so if they paid that asset out to the beneficiaries at that point in time, then they'd have a much larger capital gain event than if they waited 18 months and paid it out under an ECPI environment and paid it to the individual. Now, my comment at the time was, ultimately, you can't just do that for the tax benefit, because that's sort of failing under the concept of as soon as practical, because there's actually nothing impeding the sale of that investment right now. And so you need to sort of understand that if you take that time, then the regulator could certainly have a look at that and go, no, that's not appropriate. That hasn't been done in the right time, and maybe the ECPI wouldn't apply or whatever in that regard. And so you actually don't get the benefit that you would hope for. So we've got to pay that benefit. We've got to pay it as either a lump sum or as an income stream or as a combination of both. And of course, our ability to pay an income stream is going to be restricted in the sense that whilst it's a bit broader than this, it's ultimately to a spouse. I mean, there is a capacity to pay pensions to children, but they basically, unless they're disabled, they've got to be financially dependent and under the age of 25. So if we've got minors, as the question came through previously, if we've got minor children, then yes, you can pay an income stream, but only until they turn 25, and then the benefit is paid out as a death benefit. But we can't roll that money back into accumulation. So considerations from a compulsory cashing point of view. The key then becomes the death benefit nomination. binding or non-binding. Now, this is an interesting area I've found it, and having been involved with self-managed super funds all the way back to the late 90s in this regard, saw the evolution of binding death benefit nominations, saw the introduction of them, where they were linked very much to the 3-year rule, and the requirements of the SIS Act was binding nomination must be witnessed by two independent parties. It was only valid for 3 years, but there was always this underlying question as to whether that existed for self-managed superannuation funds. And the ATO came out relatively early in this space. I think about 2008. There you go, 2008/3, where they said that the SIS requirements don't provide for self-managed superannuation funds. Self-managed super funds needed to have binding death benefit nominations in accordance with their deed. Now, of course, we saw different results over times from the various courts, and then we got to the point with Hill and Zuda, where through the High Court, we got confirmation of effectively the ATO's position from 2008, and that is a self-managed superannuation fund can have binding death benefit nominations, and those binding death benefit nominations can be lapsing, non-lapsing, and they will set out the terms. But to be valid, the nomination must be drawn up in accordance with the terms of the trustee. So the concept of 3-year renewal periods and all those sorts of things don't exist unless you stipulate those requirements within the deed. Now, what that really means is something to be very mindful of, is that binding death benefit nominations should never be a set and forget strategy, because you take certain circumstances such as payment to a spouse, and if you have a separation, one thing to be very understanding of, and you just have to go back to the Apollo versus Conti scenario there, separation doesn't separate spouses until there's a divorce, right? And so until there is a recognition, generally through the courts, of the breakdown of that relationship, you still have a spouse. And so if you've got a binding death benefit nomination and you're not reviewing it regularly, and you separate and then you die, then there's nothing to suggest that spouse, who may very well still be a member of the fund, right, because you might still be going through that whole process, can pay the benefit out to themselves. As I said, that's exactly what happened in the iApollo case. So things to be mindful of in that regard. So Hill versus Zuda, just to sort of run through it really quickly so I can touch on a couple of other things, came through and had that exact situation where the question was raised around the validity of the binding nomination in accordance with the law or the deed, and the High Court, which is the highest power in Australia, basically came through and said, no, it is the deed, and that is ultimately our final point that says where self-managed super funds sit with regards to the validity of binding death benefit nominations. So they are still powerful, and they are still probably the greatest safety net. And I think the thing with saying greatest safety net is, you've got to understand that the courts exist and people will challenge things in the courts. And so if you have a watertight deed, and if you have a watertight binding nomination that's done in accordance with that deed, then there's not a court in the land that's going to overthrow what actions happened if it's all in accordance with the validity of that nomination. And of course, in accordance with SIS, so paid out to a SIS dependent. So if your deed stipulates how to prepare a nomination, if a nomination is prepared in accordance with those requirements, and then the payment is made, then all other parties really ultimately have no say, right? And they're going to court to lose, right? It's almost as simple as that. But if there's anything in the wording, and we've seen it over the time where people have nominated under their binding nomination to pay to the executor, right? Well, the executor is not necessarily the legal personal representative in the way that the words of SIS are written are. You must nominate either a SIS dependent or your legal personal representative. And so the executor of the estate, right, and that's what it was the executor of the estate, right, was deemed to not be that legal personal representative. And so it removed the validity of that nomination. So ensuring that people get all the words right is pretty critical in that regard. So on to, because we had a question there on the taxation of death benefits, who bears the liability and the onus to identify if paid to non-tax dependent, the trustee of the fund, or the executor of the estate when paid to the estate. Well, it's kind of a self-answering question in that regard. Ultimately, the responsibility lies with whoever's making the payment. So if the SMSF trustee is paying the benefit out to the estate, right, then the super fund itself ultimately washes its hands of any taxation liability, right? So SMSF pays to the estate. Estate has to determine who the money is being distributed to for lodging the return and paying any appropriate tax, 15% tax, if it's going to go to a non-tax dependent, right? So critical issue there. If the SMSF trustees are paying directly to the beneficiary, which is going to incorporate if it is a non-tax dependent, if they're paying to non-tax dependent, they'll pay Medicare, so 17%, then it's up to the trustees to determine who that, or whether that person is a tax dependent or a non-tax dependent. Now, this is where we see a lot of private binding rulings, and I've got a whole list of them coming up in a moment for you, but a lot of private binding rulings where people say, well, this person is in an interdependency relationship, or this person is financially dependent, and so therefore we shouldn't need to withhold tax. If you look at the balance of probabilities, more often than not, the tax office have determined that somebody isn't financially dependent or isn't in an interdependency relationship, and therefore tax should have been withheld. So you really want to make sure it's not just a shorthand process that you go through, that you actually go through the appropriate steps to determine whether or not somebody does meet that definition of not, to ensure that they get the taxation freedom of tax dependency, which is zero tax, versus non-tax dependency, which is 15%, or 30% if there's an untaxed element, which is linked to whether or not insurance proceeds exist. And of course, a lot of that's going to come down to this definition, spouse, right? So spouse is a cis dependent, right? Former spouse is a tax dependent, but not a cis dependent, right? And so that's why, the nuance between former and current is pretty critical, and that divorce, or whatever that might be, that legal separation is a critical step to be able to determine whether or not you can nominate to someone to receive benefits, or otherwise. So some pretty critical things there. A child is always a cis dependent, right? So your natural child in that regard, there's obviously different rules around things like stepchildren and that as well. And stepchildren are only your cis dependent whilst their natural parent is in a relationship with you and still alive. So that's the current approach, the legal approach that the ATO take with regards to that. But your children, regardless of age, are always a cis dependent. Children aren't always tax dependents, right? Because if they're adult and independent, financially independent, then you're going to have to withhold tax on it. So it's having the understanding of all the various elements. And as I said, when we look at financial dependency and interdependency, there's as many, and maybe not as many, but there's a lot of no's and a lot of yeses there. And a lot of the circumstances when it comes down to who a dependency is, particularly from an interdependency piece, right, is a commitment to a shared life. Right? So we often look at it and go, well, I live with my parents, or my parents live with me, or whatever the situation is. I live with siblings, and we look after each other. We both share the cleaning, we both share the bills and all those sorts of things. Somebody dies, are we in an interdependency relationship? But it's easy to say yes, right? Because the requirement is that there's a personal and domestic care, financial support, and living together, right? But when you dig deeper, one of the key things is that you've got this mutual commitment to a shared life. Now, in a lot of family circumstances, kids don't have that with their parents. Their objective is still, right, to move out of home, right? And if you're moving back to look after somebody, that's not interdependency, right? If you are, still with someone when they pass away, but you always had the future plan of leaving, then that's not interdependency, and so therefore tax is going to apply. And so there's clearly a process, because these are all private binding rulings. So this is, over a 6-month period, the number of people that have applied to the tax office to know whether or not they're financial dependency. So I would always urge people, if they're not sure on the relationship, to seek it out, to go and ask the ATO for a ruling to get the tax side of things correct. And the last piece of that too is the timing of payments. because if we know a benefit's going to a non-tax dependent, for example, then the clear message is often, well, what we need to do is we need to pay out the death benefit or pay out the benefit to the individual before they die, because if they're over 60, it's non-assessable, non-exempt if they've met a condition of release. That's all well and good until the individual dies during the process, right? And if we die during the process, then again, we've got quite a number of rulings where if you see there from an SMSF point of view, the ATO will treat it as a death benefit, not a member benefit, because ultimately, regardless of where you sit in the process, at the time the payment is made, if the trustees are aware that the member's dead, which in self-managed super fund environment is likely in 99.9% of the cases, then from a knowledge point, that's enough to say, well, it's actually a member benefit because the benefit has come out following the death. So regardless of the timing of the transaction. So a couple of key things to be mindful of. Okay, I want to finish off and talk about the reversionary and non-reversionary pension piece just to bring it up. And then I've got one more question and I'll wrap that one up in the sort of the summary piece as well. The key here when we're talking about reversionary versus non-reversionary pensions, and I speak a lot about these sorts of issues through a lot of presentations, and whilst I have my own views about it, it's always going to come down to sets of circumstances. So reversionary pensions, for example, will always provide that certainty around continuation of income, right? So understanding that the pension won't cease, the new person, the spouse will just continue to receive the income stream payments. You'll have to do a recalculation in the following year. And of course, as part of that, you get your 12-month transfer balance cap window. So for those people who have transfer balance cap potential issues, they've got 12 months to resolve it. The ECPI is clear cut. You're going to continue to get that for the entire period. The beauty of reversionary pensions is that any insurance proceeds, so you might have a TRIS that's a reversionary pension, any insurance proceeds that come in will come in with the tax-free taxable percentages of the other pension. From a Div 296 point of view, your balance goes up straight away. So, if someone dies close towards the end of the year and no action's taken, then your total super balance might have triggered that $3 million, putting you in a position for a liability for 2 years, the year of death and the following year from a reversionary pension. So that's a key one to be mindful of. From a non-reversionary pension, the pension liability dies with the member. So there's no minimum requirement to be made. That's a requirement under the SIS Act there. You would have to start a new pension and then do a pro rata calculation from that commencement date when you commence that piece. The ECPI runs out when the payment when the final payment is made. So I actually look at these and go, well, the ECPI consideration is not that different between reversionary and non-reversionary. The key issues generally come down to the minimum pension piece, right? The impact of insurance, and I highlighted that before, that insurance proceeds take on a taxable component versus tax-free and taxable of the fund. Similarly, from a total super balance point of view, your total super balance doesn't change until your new income stream commences. So the money stays within the deceased member's account until a decision is made to commence the pension, which means you could potentially defer Division 296. If there's a death benefit late in the year or a death late in the year and you don't start the new pension until the new financial year, then that individual's total super balance won't go up until the following year, potentially giving them a 12-month grace period for Division 296. So some key things to be mindful of. So as we summarize that, we do understand that from a transfer balance cap point of view, there's clearly that 12-month benefit with regards to death benefit income streams with reversionary versus non-reversionary. However, it's the flip side for Div 296 where you don't get the 12-month window. You get an immediate change to your balance, which means your transfer balance or your total super balance will be higher at 30 June certainly in some instances. So things to certainly be mindful of there. The last point I just want to make is a couple of slides here about failing the death benefit payment requirement. So if someone fails to pay the pension, now this is all material that I've retained over time because the ATO took a practical approach to this and then they've removed all this practical approach from their website. And we know that if you fail to pay a minimum pension, that the pension ceases at the beginning of the financial year. And so what that actually means is then you're in breach of the cashing requirements if the pension still exists in the fund if you haven't paid it out. And that's not necessarily practical. And so the ATO have historically said, well, if you commence a new death benefit income stream immediately upon failing or understanding that you failed the pension, then that will suffice. And I still think that that's the fair and reasonable approach to take in this regard. However, in saying that, and noting my disclaimer at the start and other things as well, is that there's no legislative backup for that, right? So it may be that if a death benefit fails to pay the minimum and then takes the action to start a new death benefit income stream, the regulator may turn around and say, no, you have to actually pay that benefit out, right? And so I would always take the approach of trying to reset the pension in the new year, and then see whether or not the regulator accept that, because the worst case scenario then is going to be that the payment will need to come out of the fund. Final piece on the child pensions, as I said, you can pay a death benefit income stream if the child's under 18 years of age, or if they're under 25 and financially dependent. And then a lump sum has to be paid once they turn 25, unless they're disabled. So if the child suffers from a disability, then the pension can continue on forever. Key thing is child pensions are excluded from Div 296, but I suspect that is going to be a very, very rare situation where you've got children or parents with minor children with a combined sum of more than $3 million, and they then both die at the same time, and the children inherit two pensions that puts them over $3 million. So it's an exclusion to an event that I think will never actually occur. But yeah, if they don't meet that disability requirement, then at 25 they have to pay the benefits out. Last bit, death benefit rollovers. So this was a change from 2017 that's been formulated now, is that, as I said before a couple of times through the presentation, once a death benefit, always a death benefit. So what we know now is that you can roll over a death benefit. You must use the death benefit rollover form to do that, because when it goes into your new superannuation fund, it needs to be retained separately from any existing super fund. And clearly a new income stream then needs to be commenced straight away. So this is normally going to occur from a spouse point of view. You know, if they want to move the money from one fund to another, they don't want the requirement to maintain a self-managed super fund moving forward. So yeah, so some key things to take away from there. One last question that we had there: as an accountant, when it's time to appoint a legal personal representative in place of the deceased client, do we need a lawyer's letter to confirm who the LPR is, or a will provided by the client will suffice? Look, this is my practical answer to that, is that the will suffice on the understanding that it's the only will, right? So unless there is question mark as to the number of wills, then I would always ask for that extract that identifies who the legal personal representative is. But if you've got a scenario where multiple wills have been written and potentially multiple LPRs have been appointed, then you're probably going to want to make that decision, or wait for that decision, subject to the mandatory nature of the transaction. So yeah, so some key issues obviously that you need to take into consideration around not only the LPR, but ensuring that your documentation is up to scratch, both the deed and any binding nominations are in place, and understanding the rules around ECPI. So look, that's it. There's a lot to get through today. I will highlight this coming month's webinar is going to be on limited recourse borrowing arrangements. And of course, that'll be 10 days after the new law takes effect with regards to LRBA. So, hopefully that'll be one that you won't want to miss either. And then we'll talk a little bit about pensions in September. So thanks for joining. As always, SuperGuardian will issue you your CPD certificates for attending, and I'll send through a copy of the slides as well. Thanks again, and I look forward to seeing you all next month. Bye for now.